Welcome to What's the Tea in L&E. I'm Emily.
And I'm Leah.
And we're labor and employment attorneys in Richmond, Virginia with Woods Rogers, Van Dieven, and Black. Leah, what are we talking about today?
Free speech. Too often I go on social media and you see people posting that, oh, I have a First Amendment right to say whatever I want. Well, the First Amendment only protects you from the government's infringement on your speech. It does not protect you. If you work for a private employer, let's say, your private employer, there's no First Amendment rights when you walk through that door. Your private employer can say, you know what? Nobody can say the word purple in this workplace. And if you say it, they can take some kind of adverse action against you.
But things that are a little more complicated for government employers because employees do have some First Amendment protections over their speech at work. And that's where this case originated, with a government employer in Ohio, a wastewater treatment plant. And Mr. Romero had been a long-term employee. He had worked at this treatment plant as a manager, as a supervisor, and eventually he retired. But a few months later, he came back in a part-time, more junior role, a subordinate role to where he used to work. And, you know, I can imagine that's pretty difficult after being the person in charge for a long time to come back in a junior role.
Yeah, and you knew the workplace. You were the big man on campus when you were there, and now you're coming back in a junior role. And so he had some things to say about that. He criticized current management for the way they were training employees and the way they were handling certain things. But he also made some complaints about some regulatory issues and data and water safety, and he called the local Ohio EPA and to try to find out whether or not the plant was in violation of certain regulations.
So, among other regulatory complaints that he made, eventually, as you can imagine, management was a bit frustrated after telling him to stay in his own lane so many times, and they terminated him in large part because he kept going beyond his job duties. And after he was fired, Mr. Romero said, "You fired me for exercising my First Amendment right to free speech in my workplace."
You retaliated against me.
Absolutely.
Well, the court came back and said, you know what? Two buckets here. They said the first bucket, your complaints about regulatory issues, those are going to be protected under the First Amendment because at that level, you are a citizen who is complaining about matters of public concern. So that was sort of the threshold. And then they said the other bucket, your gripes about management, those are not protected under the First Amendment. But that last part is key there. Why is it so key?
Well, I think it's important because that activity, complaining about management in the workplace, that is not protected under the First Amendment, but it could be protected under other parts of the law. It's something that all employers should watch out for. So really, both of these buckets that Mr. Romero engaged in, regulatory and legal complaints to his bosses, and just general criticisms of management and how things were running, neither of those should really form the basis for an employee termination.
Yeah, and so you've got other types of concerns here. So even though here in with this particular case, we're talking about a public employer, right? So the government's infringement, talk about that. But this case has broader implications or touches on broader implications for all employers, including private employers. And that is, take employee complaints seriously. If an employee is complaining in good faith about regulatory issues or even management concerns and lack of training or safety, those would likely be considered protected under the National Labor Relations Act as protected concerted activity, or even under some state whistleblower laws. So take employee complaints very seriously.
Absolutely. And we'll see what happens next in Mr. Romero's case. It's moved forward onto the trial phase with his First Amendment concerns. So government employers, just keep that in mind when you're trying to figure out whether it's free speech or just freely complaining. Well, this has been What's the Tea in L&E.
Thank you.
We'll see you next time.